How can a parent secure sole custody? Imagine trying to protect your child's future in a courtroom where every piece of evidence counts. If you're wondering how to get sole custody, stay tuned for the facts you need. Sole custody means one parent has both legal and physical control of the child. Legal custody gives the right to make major decisions about education, health care, and religion. Physical custody means the child lives mainly with that parent. Even with sole custody, the other parent usually has visitation rights and might owe child support. Courts usually prefer parents to share custody because they believe children benefit from both parents being involved. To get sole custody, you must show that sharing custody would not be in the child's best interests. This is a high standard, so strong evidence is needed. Most courts award sole custody when there are serious concerns about the child's safety. For example, if a parent has a history of abuse or neglect, courts may decide that the child needs to be protected from harm. Domestic violence is another reason courts might grant sole custody to prevent the child from witnessing or experiencing violence. Substance abuse by a parent can also lead to sole custody. If a parent struggles with drugs or alcohol and it affects their ability to care for the child, courts may decide that the child's safety is at risk. Evidence like arrest records or rehab history can support this claim. Severe mental health issues that impair a parent's decision-making or ability to care for the child can also be grounds for sole custody. If a parent cannot provide a stable environment or is unwilling to meet the child's needs, courts may decide that sole custody is best. Courts will not grant sole custody if both parents are fit and simply want to avoid communication. They prefer parents to work together for the child's benefit unless there is a real danger. The parent asking for sole custody must prove their case with solid evidence. This involves gathering records of incidents, medical reports, and testimonies from professionals involved with the child. Showing that you provide a stable home and are actively involved in your child's life strengthens your case. In some cases, courts might order psychological evaluations or home studies to assess each parent's fitness. Working with a family law attorney can help you understand your state's specific rules and guide you through the process. In Texas, for example, sole custody is called sole managing conservatorship. The law presumes both parents should be joint managing conservators unless serious issues exist. The process involves filing a petition, presenting evidence, and possibly attending a court hearing. Even if you get sole custody, the other parent usually still has visitation rights. Courts aim to keep children connected to both parents unless safety is a concern. Child support is also typically part of the arrangement. Today, courts often favor arrangements that keep both parents involved. Even with sole physical custody, courts may award joint legal custody so both parents can participate in important decisions. Getting sole custody is a demanding process that requires clear evidence that sharing custody would harm the child. Focus on documenting safety concerns, maintaining records, and working with professionals and legal experts to build your case.